Next, Adam Thierer from R Street.
Thank you, Senator, and good afternoon, committee members. My name is Adam Thierer, and I'm a senior fellow at the R Street Institute, where I cover emerging technology policy. SB2 is of particular interest to our organization because the bill represents a major effort to regulate artificial intelligence systems in a way that we believe is highly burdensome and which will undermine the successful policy model that gave the United States such a leading role in digital innovation globally. SB2 basically would import Europe's regulatory model to our shores. As with the European Union's new AI Act, SB2 is rooted in fears about hypothetical future harms associated with algorithmic systems that have not yet even been deployed or developed. As Commissioner O'Keefe correctly noted earlier this morning, quote, "We're trying to regulate fear of the unknown," end quote. And that, I believe, is a mistake. The paperwork hassles and regulatory requirements involved with the bill could have a profoundly deleterious effect on innovation, investment, and competition throughout Connecticut and the nation. The bill contains confusing, open-ended provisions that would create formidable compliance headaches, especially for smaller digital developers and companies. Only the largest tech companies will have the money and lawyers to afford the significant compliance costs associated with the regulatory regime mandated by this bill. Connecticut should not be imposing many new layers of preemptive paperwork requirements on digital entrepreneurs based on the mistaken assumption that AI systems are inherently dangerous or discriminatory by design. Instead, there are many better ways for Connecticut to address concerns about AI systems, including the many civil rights laws and consumer protection regulations already in place, not just within Connecticut, but also at the federal level and in other states. Excessive and premature overregulation of AI could also undermine many life-enriching innovations, especially in the field of healthcare, as both the Connecticut Hospital Association and the Connecticut Children's Medical Center noted in their written testimony that they both submitted about the problems associated with SB2. Finally, excessive preemptive regulation for our still developing AI industry will also negatively affect America's ability to rise to the challenge posed by China as the Chinese Communist Party looks to move ahead of us in the race for supremacy in artificial intelligence and advanced computational capabilities. For these reasons, I encourage the committee to reject SB2 and work to find a more balanced and flexible AI model for Connecticut and the nation. Thank you.
All right, Adam, thank you for your testimony. Are there any questions? All right, I just want to push back on saying we're importing a European regulatory model. This is a bill. The regulatory pieces are approximately 30 pages. The European AI Act is about 300 pages. It allows for rulemaking. This does not allow for rulemaking. So what you see is what you get with this bill. It's based off of AB. It was AB 2930. I think it was the year before. It was a different number. There was a Washington, D.C. algorithmic discrimination bill. I started talking with the Attorney General's office in Washington, D.C. in 2022. So this is not importing a European model. It's working on an American model. I would say it's not about the fears of the unknown. We are looking at actual harms that have happened. There is a 2018 lawsuit for a man in Connecticut who was denied his housing because it was based on the wrong data, right? Chris Peterson, there's an example of a man, I think it was before 2020, I can't remember the exact date, who was denied his housing in Washington. And it turned out it was based, again, on the wrong data. It was based on another Chris Peterson. In our data privacy law, we give you the right to access the data that has been collected about you and to correct it. We've added a section based off of the Fair Credit Reporting Act, passed in 1970s, early 1970s, as old as me, believe it or not, that says that you have a right in financial decisions to see what it was based on, if it's based on erroneous data, to correct that. That's all. We're looking to import that into areas where we have seen again and again there are instances of discrimination. The Amazon hiring algorithm, 2014, it was based looking to hire a technologist. Since all the previous resumes, the majority were men. Again, the representative data, it determined they wanted to hire a man. And so any women who applied were not offered an interview, not recommended for the position. So I don't need to go on, but there are countless examples. So to say this is fear-based and on the unknown is just not accurate. So how do you recommend we address these known instances, and in which cases do you think we need to act?
Senator, I have no disagreement that algorithmic systems can create real world harms. And some of the ones you've identified, I have investigated and written about. And the reality is that we should go after bad actors and we should throw the book at them. But the book should not be a preemptive sort of regulatory regime based on sort of having an algorithmic pre-crime unit that sits around and determines whether or not we can stare into a crystal ball and sort of predict the harms of the future. We actually have remedies when these harms come about. We need to allow those remedies to do their job. We can search for it and do a gap analysis to figure out where we need to improve them potentially or add additional penalties. But the reality is you don't want to have that crystal ball gazing exercise where we look around and treat everyone as guilty until proven innocent, or else we're going to end up just like Europe and we will not get a more innovative economy that benefits consumers and our nation in the great AI race.
So you're recommending a reactive approach rather than looking forward.
That's the approach we've used for the internet and digital commerce, and of course, a whole host of other sectors. Unfair and deceptive practices, civil rights laws, contract law, a variety of other mechanisms. Yes, we can have targeted mechanisms and statutes for certain sectors, and we develop those. We have sectoral approaches, both federal, state, and even local, to address more serious concerns. We can have that conversation, but this is a broad-based effort to have general purpose regulation of a general purpose technology. And that's a surefire way to undermine that technology in a very nascent stage. And that would be incredibly dangerous if that vacuum then gets filled by other autocratic nations who rush in with better, more superior systems, as China has just done last month. We heard about the DeepSeek moment with all of their new technology flooding the market. They're not going to be following SB2. They're not going to be following American law. They're going to be doing their own things. So we've got to make sure that we can stay competitive in that race and not shoot ourselves in the foot as it gets started.
You reference social media and the internet. Do you feel we should have put regulations in place on social media?
I think we do put regulations in place on social media, and we should go after people who commit crimes in any sort of digital environment using any computerized technology, period, full stop. But should we have 1996? I was there present at the birth when the Telecommunications Act was signed into law, and I worked at it in the mid 90s. We should not have had a comprehensive licensing regime for all online speech or commerce. The Clinton Gore administration made a very smart decision to make a very different approach than we had had for other previous technologies like broadcasting and others. We had a more reactive approach, it's true, and it wasn't perfect. It's not been all sunshine and roses. I would never say that. But the reality is, no, we should not have had a preemptive, fear-based regime that basically licensed and locked down all online content or determinations or commerce online.
Do you think there should be a federal data privacy law?
Yes, we do need a federal data privacy law. For no other reason, we got to make sure we clean up the patchwork mess that's been created by all the states doing this. And I fear that that's exactly where we're going with AI law. I think you probably read the recent Colorado task force report after they passed their AI law, Senator, which basically came to the conclusion we can't figure it out. We cannot figure out how to answer some of these problems that they said they were going to answer after the law was passed. And Governor Polis said, this is a real mess and we need a federal preemption framework for this. They said they'd try, but they've not come to any conclusion. We're going to have some sort of a federal baseline privacy approach and AI approach eventually.
Now, you mentioned to lean on existing laws. Have you reviewed any of the Attorney General's opinions that state that you do need to do testing on bias? The New Jersey Attorney General for the Laws Against Discrimination, the Oregon Attorney General, the Massachusetts Attorney General.
Yes, indeed. And they're making a fair point. Look, there can be arguments made about the need for greater transparency and best practices to be developed to make sure that we can identify where some of these harms do come about. I just have to say, though, that there's a difference between doing that in a more flexible, kind of best practice oriented way versus the kind of regimes that we're setting up, which are very technocratic, top down, preempted by design with all these algorithmic impact assessments and everything else, that the compliance burdens and the sort of regulatory approach that we're setting up there, we're setting ourselves up for real trouble. Again, we can talk about improving UDAP authority, unfair and deceptive practices authority, and civil rights approaches. This is a constant struggle as new technologies evolve very rapidly, but we shouldn't throw that model out. And we should understand the consequences and the costs associated with the new sort of regulatory regime that we're talking about.
Have you reviewed the NAICS model bulletin for insurance, which is, again, it's updating the Uniform Insurance Practices Act and making explicit what others have said is implied for the UDAP or the Uniform
Yeah,
Training Act.
yes, and of course, let's be clear that the insurance model is a sectoral model regulated differently than most of these other sectors and technologies, as is healthcare and many other sort of autonomous systems. We already have, for example, a separate body of essentially AI or autonomous regulatory law for drones, for driverless cars, for advanced medical devices, AI medical devices, and for insurance. And so we're going to continue to have those sectoral approaches. I'm not arguing against them. But this is very, very different than what we were discussing in SB2 and in all these other state laws. General purpose technology regulation. It would be to say, like in, 30, 40 years ago, we're just going to have general purpose computational law and then have algorithmic impact assessments for everything that happens using a PC. We don't want that regime. That would not have given us the digital revolution and the PC revolution.
So you mentioned transparency before. Do you think there should be transparency requirements? Because how are you going to utilize existing laws? Two things. One, if you don't know that AI is being used to make an important decision, but two, because of the black box nature of the way the decisions are made, if you don't have any insight into how the decision was made.
Well,
How
sure,
suffice?
certain transparency requirements are understandable, and I understand certain types of requirements being necessary, especially as part of data security, data privacy law. It is a difficult line drawing exercise. We do not have perfect transparency for every so-called black box system in existence today. I mean, every time you get on a plane, Senator, we obviously are flying in a system that's very much driven by autopilot. And yes, it is regulated, but the reality is we don't have transparency requirements all over the place saying autopilot is on now, right? Do we need that sort of perfect level of transparency? We don't have perfect transparency for everything that happens within all of our digital systems. And so you do need it for certain sensitive matters. I understand that. But again, the reality is that we can address the actual real world outcomes. This is what Commissioner O'Rourke talked about this morning when he talked about don't regulate fears, he said, quote unquote, regulate outcomes. That's the single defining principle that we should regulate AI by. Looking at real world outcomes and harms, not inputs or hypothetical problems on the front end. Let's make it about the real world.
So you were advocating for remediation over regulation, letting people, let's see what harms come, and then
Well, Senator, remediation involves regulation. And let's not forget, we're not even talking about legal action in our courts. We have the most overly litigious society in the whole world. We have many mechanisms to correct for harms and problems as they develop. We also have other bodies of regulation we never discuss. I'm a big fan of, for example, recall authority and the ability for regulators to pull back products off the market after they've been shown to actually have some problems. But the key part of that model is that regulation is ex post and it involves actually allow innovative products to get out there in the real world and see what happens. We don't bottle them up on hypothetical fears and say, oh, what might happen if we allow that into the wild? We allow it. And then we make sure we address it and hit them with the books if something goes wrong.
Great, thank you. Well, I'm just going to go back to your analogy to the plane. And I think that, again, I'm going to what I believe in is a risk-based approach, right? Planes are tested before they're flown. They're tested at a higher level than cars. Cars are tested before they're driven on the roads. They're tested at a higher level than bicycles, right? And so if you're making an important decision about someone's life, we don't say you need to regulate chatbots, although I think there are good arguments based on what happened in Texas and in other places where chatbots went off the rail for regulating them. But lower risk cases where you're using AI to make yourself more efficient, to improve tasks, we're not regulating. We're looking to put in guardrails when you're using AI to make an important, sometimes irreversible decision about someone's life. And again, I'm not saying not to use it. I personally want people to use it. I want to embrace AI. We're just saying stop and test it like you test a car, like you test an airplane, like you test, my grandparents made toggle switches, like we tested the toggle switches before we shipped them.
Yeah, and indeed, we have a sectoral approach for certain high-risk categories of technologies, but it's a very limited approach in terms of how aggressive we get with these things. Even with regards to AI, ML-related medical devices right now, our Food and Drug Administration at the federal level is trying to have a more relaxed approach to make sure that we have life-saving, life-enriching drugs. And we have to make sure we don't over-regulate when we take those sectoral approaches. Why is it that the Chinese lead the entire world right now with DJI leading in drones and other types of robotic technologies? It's because over-regulation of autonomous systems have made sure that we don't have an autonomous, flying systems market in the United States. We over-regulated that. And I could go into many other examples of this where we got it wrong, where AI right now, or autonomous systems at least, are highly overregulated, and we need to relax those rules. So we have to have some balance here and understand it's got to be targeted, sectoral. Yes, I understand some precautionary rules here and there, but the reality is even those can go too far sometimes.
And I would argue that we do have some good automated flying technology, especially, being the home to Sikorsky and an electric boat. But I know the technology is employed by Sikorsky and in our defense industry. But thank you very much for taking the time to come here to
Thank
testify
you.
today. I don't know if I see any further questions. So thank you.